all rise. Court of Appeals Division 1 is now in session.
Please be seated. We're here in our case 1CA UB21-0275, Pittman versus ADES. Each side will 20 minutes to present the argument. You may save as much time as you want for rebuttal, but you'll have to keep track of that on your own. We have a clock at the podium for that purpose. We are recording the argument both in audio and video, so when it's your turn, please identify yourself and your client so that we can keep everything straight. The argument should appear on YouTube in a day or two so you can see how well you did. We've read the briefs and conferenced the case, so we're familiar with the facts of the law, so when you begin your argument, just start off with what you would like for us to know. Counsel, you may begin.
Thank you, sir.
Good morning, Your Honors, and may it please the Court. My name is Greg Iannelli, and I represent the appellant, Angelica Pittman, who is here with me today. I'll try to reserve a few minutes for rebuttal. Your Honors, DES denied federal PUA benefits to Ms. Pittman under the CARES Act.
Counsel, did they deny all benefits or only part of them?
All benefits were denied, Your Honor, under the CARES Act. And the reason for the denial, or the grounds on which it's being defended in court today, is that Ms. Pittman was not, quote, available for work before the pandemic, applying its odd jobs exclusion, which I'm sure you're familiar with from the briefs. And yet, Judge, at the administrative hearing in this matter, Ms. Pittman testified that she went out and worked Monday through Friday every day, making the ALJ concede that Ms. Pittman was, quote, working really hard and had some hustle. So I would submit, Your Honors, that a person who is working really hard Monday through Friday every day is by definition available to work.
Well, Counsel, as I understand the CARES Act, one of the conditions in situations like this is self-employment, which requires that the person's primary income come from the self-employment. I'm not quite seeing that.
Okay, so two things there, Your Honor. First of all, there actually is no requirement under the CARES Act that the applicant have lost their principal source of income. That's actually in the Secretary's guidance itself, so that is not a requirement of the statute. As to self-employment, that is one prong under subsection 2 of the Act, that you can prove that you were, unlike traditional unemployment programs, you can prove that you were self-employed. However, the one...
What if you were just making, though, say $50 a year total? Do you fit the definition that you're self-employed, but they do suggest that self-employed individuals whose primary reliance for income is on the performance of that work. And if it were $50 for the year, is that the primary reliance?
Well, so Judge, the prong that's applicable here, or most applicable, I think, is that which says that the person is eligible if they don't have sufficient work history. And how the Secretary has defined...
Isn't eligibility different than, it seems like this is a definition, you're a self-employed individual, but their definitions that they've they've proffered, the federal government has said it's a job and that you're primarily relying on which you're primarily relying for income. So that seems different than I'm available and willing to work. If it's just, yeah, I'm available and willing to work at something that pays me $50 a year, does that get you there?
Yeah, so again, there's actually two. The available and willing to work is one condition. If you actually look at the record, that's not really disputed in this case. The second condition is that the person has to have had some kind of work history before the pandemic, because the CARES Act is far broader than typical unemployment insurance. And so you've got to demonstrate you were doing something. Now, what do you have to demonstrate? This gets to your question. And the Secretary's guidance in Uninsurance Employment Program Letter Change 4 is that you have to have shown a recent attachment to the workforce, meaning that you worked at some point in the applicable tax year, which in this case was the year before the pandemic started. So worked at some point is the guidance from the Secretary. Now,
but you're saying there's no limit as long as you worked for 3 hours in the period before that's enough?
Sure. I mean, I think there's some room, obviously, for judgment and discretion on that, and the court doesn't have to go nearly that far to resolve this case. The problem in this case is that DES has applied this interpretation in its rule, or what purports to be a rule, that says categorically, if you were working in odd jobs, then you're not qualified no matter what the other circumstances may be. Essentially what they've done, and especially if you read the argument in the brief, is to say, the Secretary's instruction says lacking sufficient work history, meaning you have a recent attachment to the labor force, meaning that he or she worked at some point from the start of the applicable tax year to the date of filing. They would add the words, worked at some point full-time, from the start of the applicable tax year to the date of filing. In other words, they would require the applicant to show that before the pandemic, at some point during the year, they had a full-time job.
But would it be okay if they just substituted in the term that you were working at something on which you could primarily rely for income? Is that very much different than saying, I realize it's not necessarily full-time, but it seems like more than 3 hours of babysitting in an entire year. And I'm not suggesting that's what it was, but I'm just trying to figure out if there are any boundaries to this.
Right, yeah, so first of all, I think that hypothetical is not really this case, because Ms. Pittman testified she worked Monday through Friday every day, and this was her, aside from food stamps and Section 8 for her rent, this was her principal source of income.
So I just want to make sure that I understand your argument. Your argument is she worked Monday through Friday, and in the course, according to the transcript, she worked Monday through Friday all year, supposedly, and she made $629.
Yeah, she did not make a lot of money, Your Honor. The record reflects that the primary bulk of the time that she spent working was collecting metal for recycling purposes. And you don't get paid more than a few dollars for doing, it takes a lot of time and effort, but you get paid by the pound. And when you get paid, it's not very much money, and so you're not making money at that every day. So she had other things to supplement that as well, or she would do computer repair and babysitting and artwork, and she would make dolls and costume jewelry and these sorts of things and sell them online. She had a gig with this company called Field Agent, where it's like an app like Uber or Lyft, where you get a call to go to a store and do a review or mystery shopping or that kind of a thing.
So is your argument that her primary reliance was on these odd jobs that she was doing for her income?
Yeah, as the Arizona Supreme Court stated in the Pittman case, one can make a full week's work for oneself out of odd jobs, and that's what she did. And the other half of part of your question, Judge Connie, is on this concept of sort of like principal source of income. Under prior regulations governing a general disaster assistance relief that's similar to this program, one would have to show that you lost your principal source of income in order to qualify for benefits. That was eliminated for purposes of the CARES Act and the Secretary's guidance. So even if she were getting money from other sources, and this was sort of just like a little side gig to make a little money for going to the movies or whatever, that would be a different situation. So I don't really think that concern is applicable here. It would be for other programs, not for this program. So as I stated, the state would read in the words full-time into this guidance, and that's simply not the law. If you look at the CARES Act itself, in subsection 2, a person who before the pandemic was seeking part-time employment is eligible for benefits. And then if you look at
Council, what was the specific basis for denying benefits before the ALJ and the appeals board?
Yeah, thank you for that question, Judge Howe, because I think it's material. The basis for denying her was that she failed to show sufficient pre-pandemic employment, meaning this question of work history. What was she doing before the pandemic?
And was the ALJ not entitled to think, well, she's not earning what you would think someone would earn working, full time. So that's just not enough. I mean, why couldn't the ALJ reasonably find that?
Well, there's no controverting evidence in the record. And as this court held in the Simmons case last September, it's error to deny a claim for PUA benefits when the claimant testifies, there's no controverting evidence, and there's no credibility determination. And here, that's exactly this scenario. She testified exactly what she did, that she went out and worked Monday through Friday every week, that she didn't make a lot of money, but made enough money to, on top of her Section 8 and food stamps, to support her daughter and provide for her, as many Arizonans are forced to do. And there was no determination made by the ALJ that testimony was not credible, nor was there any controverting evidence admitted in the record. And so, setting aside...
Isn't arguably that the controverting evidence is arguably that only $629 doesn't reflect, and even assuming it's part-time work, but if we start getting closer to that, someone who only made $50 a year babysitting twice, and if you're, I was understanding you to be agreeing that there's some discretion on the part of the court, and if there would be discretion presumably to say that $50 babysitting for 2 nights you don't qualify, where does the discretion begin and end if the court is saying, well, $629 doesn't seem like it's meaningful employment that we can call you self-employed under this definition? Yeah.
So, I think with the idea, first of all, the problem here is that there was no discretion exercised. The ALJ applied a rule that said if your employment consisted of odd jobs for a few hours weekly, even if you did odd jobs for a few hours weekly for the entire year and made enough money to support yourself, however you managed to do it, doesn't matter, because here's this rule that was not promulgated under the APA or disclosed to the public. That's in my program guidance that I got from DES. It says you're disqualified. That's the problem here. There was no discretion exercised.
But doesn't the brief from the amici here kind of controvert that? I mean, they demonstrate that there have been people who could have arguably been doing odd jobs and did get benefits.
I'm not familiar with those cases, Your Honor, and I don't know what was done in other cases. All I really, in this case, whatever maybe other judges have handled this guidance differently, other ALJs, but this ALJ said because she was only working odd jobs, I'm going to disqualify her. As to the $50, at some point I think there would be different grounds for disqualifying that sort of thing. For one thing, if you were only babysitted twice during the entire year and that's what your work was, are you really unemployed because of the pandemic, which is another thing you have to show. I mean, here Ms. Pittman showed that all of these odd jobs that she was doing consistently, throughout the year, dried up because of the field agent app was shut down because the stores were closed. Her daughter was home from school, so she had to supervise her and couldn't do the recycling. People didn't want to hire her to send her artwork and things because they were afraid of the virus. If you're only babysitting twice a year, maybe 6 months before the pandemic even started, I think you would probably be disqualified for failing to show unemployment because of one of the COVID-19 related reasons.
Counsel, I sympathize that you're just dealing with the facts of your client that you find yourself in. But if we were to say that your client should have gotten benefits, we have to decide what that rule is. That rule will apply in other cases. I think we're concerned that what's a limiting principle? What is a principle that would allow your client to receive benefits, but somebody else not?
Well, okay, let me ask you that question two different ways, Your Honor. So the first way is, I don't think the court has to go that far in announcing a rule. The rule is in the Secretary's guidance, and it says you have sufficient work history if you worked at some point in the preceding tax year. What we're asking the court to hold is, in order to demonstrate that, you don't have to demonstrate that you worked in full-time employment, which is the argument being made by the state. And that the fact that you made up a full week of work throughout the year by doing odd jobs for a few hours weekly, one after the other, after the other, after the other, is not an automatic disqualification.
But what if we agree with you that the fact that it's an odd job isn't a basis for denying it? Do we send it back and have them go through the analysis of was this enough for a job for which there was primary reliance for income?
Certainly, I think the court could do that. The court could decide that there is, the way that the ALJ handled this was inappropriate because the ALJ applied a mechanical rule rather than evaluating the actual facts of the case. However, I think on the record, so that's certainly an option if the court feels inclined to do that. I think on the record, as it presently stands, is sufficient to remand simply for an award of benefits on the basis that she did testify without dispute that she did work for the time period that she worked in the various jobs that she worked.
But did she avow that this was her primary source of income, or is that,
That's not a requirement of the statute, Your Honor. But I think she did. She did avow that, aside from the food stamps and those kinds of things, this was her income. This is what she used. This was not, like the high school kid who comes home and does mowing to earn $10 to go to the movies. This is the money that she used to support her family. That is in the record at pages 65, 68, 78, 79, 80, and 84 of the appendix. So that's not a requirement of the statute, but I think here it is certainly satisfied.
Okay, so to talk about the rule, I have serious questions whether this backroom policy is a rule or not, but assuming that it's a rule, isn't it consistent with the definition of self-employment that that you have to primarily rely on your self-employment for income? Can't you read the odd job exclusion consistent that way?
I don't think you can, Your Honor, because again, as the Supreme Court held in the Pridgeon case that's cited in our briefs, you can make a full week's work for yourself out of doing odd jobs, and that's what occurred here. Furthermore, if I maybe can leave you with anything today, it's that self-employment is not the only way that one qualifies under the CARES Act. One can also qualify if simply by not having a sufficient work history, in other words, sufficient wages and covered employment to be eligible for regular unemployment compensation benefits. And so I think, so actually when you read the DES policy, that's where this odd jobs exclusion comes into play. It comes into play under the definition of lacking sufficient work history. And so again, when you read with the Secretary, how he defines that term, there are three parts to it. Two of them are not disputed. They have to do with wages and covered employment, those kinds of things that are not at issue here. The part that's at issue is this, you have to show something. You can't just come in off the street and get money. You've got to show some kind of work history, which the Secretary says means that you worked at some point. Ms. Pittman worked at some point. She worked Monday through Friday every day in her uncontroverted testimony. And so according to DES, though, that's not enough. You have to have worked at some point in a full-time job. That's the only explanation that they've given for this in the appellate briefing that I've read or could discern there. And that's simply, aside from adding words to what the Secretary wrote, which is problematic in itself, it's simply incompatible with the intent of Congress. And actually, there's a case cited in our briefs, the Muse case from Minnesota, which involved a high school student who was working part-time and was disqualified for that reason. And the court reversed that and remanded for benefits because there is no part-time exclusion. So, the duration or regularity of how much she was working, whether it was odd jobs or full-time work, is not consistent with the Secretary's definition of what it means to lack sufficient work history.
Council, we've asked you a lot of questions. We'll give you a minute in rebuttal.
Okay, thank you, Your Honor.
Thank you.
Good morning, Your Honors. Excuse me. May it please the Court, my name is Jennifer Bloom, and I am here today on behalf of the Arizona Department of Economic Security. The Department of Labor has made it very clear through its program letters that it's issued to the states that the Pandemic Unemployment Assistance Program was never intended to be a benefit based on financial need. It's an unemployment benefit. And the Department of Labor has made it very clear to the states that they have an affirmative obligation to rigorously ensure that only persons who are eligible are actually receiving these benefits. And one of the conditions that they've placed on this is that a person needs to show that this is money that's replacing their former source of income. This isn't just money because they were affected.
So Ms. Bloom, where does it say that?
So we have, first, just in general, the fact that the Department of Labor has repeatedly said only people who are eligible for these benefits can receive them. And that implies that, okay, we're not looking at just anybody affected by the pandemic. We're looking to a class of persons. Second, we have in charge letter, 1620, I3, it does talk about that a person needs to show that one way they can show self-employment is, like Judge Katani mentioned, that their primary reliance for income was in services performed for their own business or on their own behalf. And if you look at that definition, it says that somebody who is performing gig-type jobs is considered self-employed for purposes of the CARES Act.
Well, and Council, I'm confused about why working odd jobs is not gig employment. Is there a definition of what gig employment is? Well, you would agree that if it is truly gig employment, that's fine.
Yes, Your Honor, I am actually not contesting at all that there is any distinction between odd jobs and gig employment.
But she seemed, Ms. Pittman seems to have been doing a lot of jobs. That sounds like gig employment to me.
That is, my understanding of the ALJ's ruling is that It's not a categorical exclusion that nobody who's doing odd jobs or gig employment, whichever term you want to call it, is excluded from benefits.
Well, then what's the purpose of the exclusion then, if it isn't categorical?
The exclusion is, as Judge Katani mentioned, to ensure that people are can show that they have a sufficient work history.
Well, and why didn't they say that? They didn't say that. They said odd jobs. So they equate, under your view, then the agency equates odd jobs with lacking a sufficient connection to the workforce. A, if that's what they meant, wouldn't they say that? And B, that seems inconsistent with the CARES Act allowing benefits for gig workers.
Well, Your Honor, I was not on the drafting committee, so I can't speculate as to what their reasoning was for this specific language. But the DES's point here was not really about the type of employment.
Well, and I guess my question to you is, I accept that's what you're saying, but I don't see any proof of that. I don't see any proof that, well, when they say odd jobs, that's not what they really mean. But we have to go by what the words say, and the words say odd jobs, and that seems categorical to me, and that seems inconsistent with the CARES Act.
Respectfully, Your Honor, the policy doesn't end at a person doing odd jobs is not eligible for benefits. It specifically states that a person doing odd jobs a few hours a week is ineligible for benefits. So it's not a categorical exclusion on anyone who's making their living through odd jobs or gig economy, however you want to phrase it.
But she says she's working full-time doing this. Whether she's successful at it, and that's a different question.
And I think that is a question of credibility and discretion that the ALJ had the ability to make in considering the testimony that was presented to her and the evidence.
Could I take a step back and one of the first questions we ask? The rules changed at some point prior to December 30th, 2020. The only requirement was that you self-certify. What's the basis for denying benefits up to that point?
So condition 2 only requires self-certification, but in looking at the CARES Act, condition 1 actually does not say that self-certification is the requirement. And again, the Department of Labor has, sorry, it looked like you were about to.
Well, so what it looked to me like, as long as you made the certification that I'm available and willing to work and that I was working before, without needing any documentation, it seems like it was the federal government's intent, and it's the federal government's money, and if they want to give it away, it seems like and not giving it away, but if they want to make it available, it seems like they're entitled to do that. And if you're not disputing the self-certification.
I'm not disputing self-certification as to condition 2.
Okay, so I interrupted you. What's the basis then for denying benefits before the documentation requirement went into effect?
The department's position is that we still had an affirmative obligation to determine whether or not people were eligible, and that's outlined in the
Isn't that inconsistent with it? All you have to do is self-certify. It seems like you're writing something into the CARES Act that's not there. Well, you said as long as they certify that, it seems like they wanted to make money available to people who needed it right away and didn't anticipate having lengthy hearings. There wouldn't have been any need for this additional requirement if there was some kind of obligation to do that, the type of assessment you're suggesting.
And again, the self-certification provision was in condition 2. It's not in condition 1. And as to the department still has an obligation to ensure that we're giving out benefits to people who are eligible.
So you're saying they had to provide documentation even though that was a requirement that went into effect later on?
Not as to condition 2.
Right, but the condition 3 is what I'm talking about, where they specifically said, now you have to provide documentation. And they specifically said, as for benefits, I've already forgotten the precise date, but sometime in December. How can we read that other than prior to that date, as long as you self-certified, you were entitled to benefits?
While I'm answering that question, I will remark that at least some of Ms. Pittman's claims are actually after that December.
I understand that, but I'd just like to clarify, your position is you still don't think she's entitled, even though she's self-certified, and there didn't seem to be a documentation requirement. It was the department's position that those people were not automatically entitled to it, that the department had some obligation to investigate whether they were actually
Yes.
making money.
That is the department's position.
If,
Do you know if any other states, sorry, did any other states take that position before the documentation requirement?
I don't know for certain, and I wouldn't want to speculate and provide any misinformation, Your Honor.
It just, we had looked there didn't seem to be a lot of cases, and it seemed, perhaps because the states weren't, this was money that was being made available by the federal government. It seems odd to impose additional requirements when the federal government hasn't said there is an additional requirement, and they subsequently, in fact, add that requirement. So it seems odd for the state, but anyway, you're saying you're not aware of other states taking that position or not?
That's correct, Your Honor. And
Counsel, if the ALJ denied benefits solely because Ms. Pittman was working what he termed odd jobs, then without more, would you agree that would be error?
yes, if it was an exclusion based solely on the type of work that Ms. Pittman was performing, the department would agree that would be error.
Then what is in the ALJ ruling that indicates that the judge went beyond that in denying benefits? You argue that the ALJ made a credibility determination. What reflects that in the record, that's what the ALJ was doing?
The ALJ specifically stated that her finding was based on Ms. Pittman's lack of attachment to the workforce. She didn't expound on that point, but she did hear the testimony that was in front of her, and so I think it's reasonable to infer that she did make a credibility determination.
But the ALJ said that Ms. Pittman showed hustle, so it shows that he credited her, I take it from that comment, that she was working. If she shows hustle and she's working, that by itself would indicate that she would be eligible for benefits. So there must be something else.
Without knowing more of what was on the ALJ's mind, I can say perhaps the ALJ then, after the hearing, took a closer look at the record and decided that the evidence within the record wasn't consistent with the testimony, or perhaps she was intending to be kind when Ms. Pittman was testifying.
Was there a specific reference, I apologize, we could look at the ruling, but was there a specific reference to the amount earned over the year?
I left my binder with that over at counsel's table. If you would like me to find that, I certainly
Please.
can.
Sure.
So in the ALJ's findings of fact, which is at index 2, page 2, she does recite facts about the claimant's income. I don't think she specifically cites the $629 figure, but she does make a recitation of Ms. Pittman's sources of income.
In making a finding that there was not an attachment to the workforce?
These are the general findings of fact that she recites before her conclusion.
Where did the odd job exclusion come from? I take it the agencies treating this as a rule, but it wasn't adopted through the APA, and I suppose it could be an emergency rule, but there are requirements even for emergency rules. So, from my reading of the record, weren't followed. So, what's the legal status of the exclusion?
So it was not entered under the APA. However, the department was operating during pandemic conditions. It was attempting to implement this program as quickly as possible so that we could start getting people their benefits. At the time that the PUA Act went into effect, Arizona was under Executive Order 20-02, which prohibited rulemaking except under some fairly exacting requirements. For example, the department would have had to identify 3 other rules that could be eliminated before it could institute any new rules. And any new rules also had to go to a special committee to be considered and approved. The department had a number of employees who resigned when the pandemic hit, and a number of employees who were working remotely who had never done that before and they didn't have the infrastructure to support remote work immediately. And frankly, it simply wasn't possible for the department to comply with rulemaking procedures under those conditions. Well,
if it didn't, then what's the validity, what's the legal effectiveness of the exclusion then, if it wasn't properly adopted? Does the agency have authority in those circumstances to enact a rule anyway, even though it can't follow the proper procedure?
So the agency's position on this is 2 parts. One, that this is precluded under 41-1993B because it wasn't raised in the petition for board review, and that is a statutory limitation. It's unlike procedural waiver, which the Evenstad case cited in the reply brief is a case that concerns procedural waiver, which is discretionary. This court can choose to find something waived or not. 41-1993's limitation is a statutory exclusion.
Well, counsel, the issue that's argued in the brief is that federal law preempts state law, that the CARES Act would preempt the state law. That analysis presumes that we have a valid state law to be preempted. So I believe that the conflict between the CARES Act and the exclusion was raised, is properly before us. That's what we're arguing over. So isn't the validity of the state rule a subsidiary issue before we get to preemption? So how can it be waived, even statutorily?
My answer to that would be it's very similar to objecting to a piece of evidence at a trial. There's the Lopez case, which says that if you object to a piece of evidence on the basis of foundation, your underlying challenge is this evidence isn't valid and shouldn't be before the court. But that doesn't preserve an objection as to hearsay or any other basis that you might have for objecting to that.
But that presumes that there are independent grounds. The validity of the rule would seem to be a preliminary question to whether it's preempted or not.
I did not consider it that way, Your Honor, so I don't have another answer to your question.
I just want to clarify, are you saying that the position of the agency is that the odd jobs exclusion is a rule that should have gone through rulemaking and did not?
The agency's position is that that issue is not before this court.
I understand that. My question is, was it a rule that should have gone through rulemaking?
It was intended as guidance for the program. So whether or not that it did not intend, I'm sorry, I don't have a better answer than that.
Thank you.
And I appreciate the emergency nature of it, and it was, obviously the federal government wanted state stat quickly, but doesn't that counsel more in favor of erring on the side of, particularly when the only requirement seems to be self-certification, that they're self-employed, that they've been trying to get work, they're willing and able. I understand the problems in going through all the procedures to adopt rules, but I'm still struggling with why the state would not just view that as a reason for erring on the side of granting benefits that the federal government is paying and it's not coming out of the state's pocket, and the federal government seems willing to do it before they've got a documentation requirement. That's what's puzzling to me.
Certainly, Your
Sorry,
Honor.
that's not a question.
I would just say again that the federal government was at the time continuously reminding states that they had to be ensuring that they were properly administering these programs. And in letter
But don't you
20
do that by ensuring that that there's at least self-certification? If there's not self-certification, then certainly you shouldn't award benefits. But if there's self-certification, that seems to encompass all you need, at least for that period up until the date in December.
The Department of Labor reminded states that they needed to have rigorous assessment procedures to ensure that people claiming benefits were qualified, even if they self-certified. The information that they provided still had to show that they were actually eligible for benefits. I see that my time has run. May I have the court's permission to make one final point?
Surely.
The final point that I would like to make is that if this court does determine that the ALJ erred, the proper remedy is remand. Generally, when an administrative board has applied an improper standard, remand would be the proper remedy. And in this case, there are remaining factual questions. Because the ALJ determined that Ms. Pittman wasn't qualified under Condition 1, it didn't make any determination as to Condition 2. And one thing specifically about Condition 2 that might be at issue here is that Ms. Pittman claimed as her qualifying reason, or one of her qualifying reasons, that she was required to stay home to care for a minor child due to school closure. However, in 1620 Change 1, the Department of Labor clarified that if a school is closed for the summer, as it would typically have been before the pandemic, then school closure to care for a minor child is no longer a qualifying reason. So there are probably other factual issues that remain to be determined upon a remand.
Thank you, counsel. We appreciate your argument today. Counsel, when you do rebuttal, can you talk about the basis for the ALJ's ruling, whether it was credibility or whether it was the job exclusion?
Thank you for the question, Judge Howe, and thank you for the opportunity to present the rebuttal. Candidly, Your Honor, I think that the ALJ had no factual basis for her decision. We heard the state concede that the fact that it was odd jobs alone is not enough. There would have to be more. The more factor that's recited in the decision is that she was doing these jobs, quote, for only a few hours weekly. There's no record support for that whatsoever. Testimony in the record is that she went out Monday through Friday every day from 7 o'clock in the morning till 4 o'clock in the afternoon. that was just for the purpose of collecting the scrap metal. She had other work on top of those things that she would do throughout the week. So the notion that this was work that was done for only a few hours weekly, totally unsupported by the record, and for that reason alone, the decision of the ALJ was clearly erroneous. I think that the issue here, as Judge Howe pointed out, is that Ms. Pittman has been punished because she was not successful, relatively speaking, at her various jobs. That she had a lot of hustle, she worked really hard, she got out there and did the work, for whatever reason, didn't make a lot of money, and that's the reason why this was treated as disqualifying, and I think that's unfortunate, and that's what deserves this court's attention and remedy, a remand for award of benefits.
Thank you.
Thank you.
Thank you, counsel. We appreciate your arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.